So today we're going to talk about wills. Now, I'm not professing to know everything about it. I'm certainly not a lawyer, but my hope today is that I'm going to plant some seeds to motivate some of you that don't have wills to go out and get one. So this is Curbside with Crystal. Now, before I get onto today's topic, feel free to subscribe to my YouTube channel and follow me on all the social media platforms so you can stay up to date on what's going on in the market, home renovation and tips and different things like that. And so I know I'm not talking to myself. So on to today's topic. So a will, which is also known as the last will and testament, is a legal document that outlines a person's wishes for how their property, assets, and affairs will be handled after their death. Now, a will typically designates an executor, and this person is going to be responsible for carrying out the instructions in the will and distributing the assets to the beneficiaries named in the document. So the executor is a big role, and oftentimes it carries on for some time. Now, in a will, a person may also name the guardians for any minor children that they have, spell out any charitable donations they want to make, and provide any instructions on the distribution of their estate. Now, there are some legal requirements for making a will in Ontario, and some of them are as follows. So first of all, the will must be made by you, and you must be of sound mind and over the age of majority in Ontario, which of course is 18 years old. And again, you must make the will for yourself by yourself. Nobody else can make a will for a third party. Now, you must sign the will and the document in the presence of two valid witnesses, and your witnesses must also sign the last page of your will together with you. Now, your will must be signed in wet ink and stored in a physical copy. So this means that at this time anyway, it cannot be an electronic or an emailed or DocuSign document. It has to actually be signed in ink. Now, your witnesses, again, must sign the last page of the will together with you. So what happens if you don't have a will and you pass away? Well, obviously, the way that you wanted things distributed may not happen. Perhaps you wanted to leave an old friend some money or some belongings or different things like that, or maybe it's a neighbor down the street. If it's not in writing, then this will likely not happen. So typically, it goes sort of through the hierarchy of immediate family. So your assets will be distributed to your spouse, and then your children and grandchildren, and so forth and so forth. So starts with the spouse. If you don't have a spouse or if they're already deceased, then it would go down the line from there. But this may not be how you want your assets distributed. So again, it's so important to put your wishes in writing and to do it properly.